The Firm, India's only show on corporate law, tax and audit matters.
Over 3 crore cases are pending in courts across India. You'd think those involved in a commercial dispute would much prefer arbitration to litigation. Except that in India, arbitrations can sometimes run as long as a court case. Time delays, high costs and judicial interference are all reasons why arbitration in India is often ineffective. The 20-year-old law has been ripe for amendment, and those amendments have now come via an ordinance. While the form may not be ideal, the substance breaks new ground. India is now probably the only country in the world to fix a time limit for arbitration, and also amongst the first few countries to fix fees for arbitrators. Well, to discuss the amendments to the Arbitration and Reconciliation Act 1996, I am joined today by Justice A P Shah. Justice Shah was the chairman of the Law Commission when it submitted its report on the changes required to the Arbitration Act. I also have with me in Mumbai a very well-known arbitrator and a lawyer on the arbitration side, Birendra Saraf, and the client, that is the General Counsel of the Aditya Birla Group, Ashok Gupta. Justice Shah, gentlemen, to all 3 of you, a very warm welcome. Justice Shah, I'm going to start first by highlighting the most unique feature that this ordinance brings in, and that is fixed timelines. This was not on the list of recommendations that the Law Commission made. What do you think of this feature?
The timelines are, according to me, unrealistic, and this is going to increase the judicial interventions, and consequently it would add to the delays. There is nothing like this particular provision says that the award has to be delivered within 12 months, arbitration proceedings to be completed and award should be given in 12 months, and by consent this could be extended to another 6 months, that is 18 months, and thereafter the party has to approach the court to get further extension. This provision also provides that if the arbitrator decides the case within 6 months, then he will get some extra fee to be decided by the parties, and if the court finds that the arbitrator is responsible for the delay, then his fees will be reduced by 5% for every month. According to me, I mean, this provision is very undesirable, and I had spoken to the Prime Minister, to the concerned ministers. I oppose the introduction of this particular provision. These timelines were discussed in the several meetings of the Commission, where the several judges, lawyers and academicians were involved, and this was expressly rejected by the Commission. Now just consider, there is nothing like average timeline for an arbitration. The time required for an arbitration depends upon the technical or legal complexity of the case or the volume of evidence. Now it's not proper to say that it has to be decided within 12 months or 18 months. It is revival of the old provision. That is, there was a provision under the old Act which said that the arbitration has to be completed within 4 months, otherwise the parties had to approach the court for extension. Secondly, this carrot and stick policy, according to me, is completely undesirable. It says that the arbitration should get some extra fees if he finishes the case in 6 months. It's like telling the court or the judge that if he decides the case within a particular time, he will get extra salary. And this idea of deducting the fees is, according to me, I've never seen, I never heard of such practice in any part of the world, that the arbitrator is penalized for not finishing the arbitration in time. I personally feel that this provision will really adversely affect the arbitrations in India. Government is saying that they want India to become a international hub for international commercial arbitration, but I feel that with this international party, no foreign party would be interested in conducting arbitration in India. On the other hand, even the domestic parties would prefer to go to other forums to seek their disputes adjudicated.
Besides the flaws that you've pointed out, Justice Shah, I want to point out one more thing. Do you expect that because you require the court's permission to extend this, further than the timelines that you've pointed out, which is 12 to 6 months, that we're going to end up seeing a pile of applications to the court, in a sense, all of it will go and end up or get clogged at the High Court level or the court level.
Yes, Menaka, this is absolutely correct, because the courts there's huge pendants in courts. These applications, though the section provides that the application shall be decided within 60 days, but please believe me, these applications are going to take months and perhaps years together. And another thing which is very startling, in section 85A, which the commission drafted, a scheme was laid down as to which provision would operate prospectively and which would operate retrospectively. Now I'm not sure whether 29A is going to operate prospectively or retrospectively, whether it will affect the pending proceedings as well. I mean, on a fair reading of the law, I'm of the view that it will not apply to the pending proceedings, but this again it is going to lead to some litigation, and this will really it will mean that most of the arbitrations which are already crossed 18 months, the duration is over 18 months, they will all come to a standstill. I see really the whole effort of the Law Commission to bring the reforms is undone by this one provision. I strongly appeal to the government that they should reconsider about laying the timelines. And what we suggested instead, that the arbitrator should give in writing that he is in a position to decide the matter, say within a period of 2 years. We said 2 years. And secondly, we also made provisions for day-to-day hearing, discouraging the adjournments, and also we propose powers to the arbitrator to impose exemplary cost on a party which is trying to delay the matter. I think these provisions are sufficient to take care of to ensure that the arbitrations are decided in timely manner, and it's really not necessary to fix some timelines. I mean, I find it very odd, honestly.
Okay, fair enough, sir. I'm going to put your thoughts to both my guests here in the Mumbai studio. Mr. Saraf, would you agree that, as Justice Shah says, the imposition of this timeline may in fact make India less attractive as a place to arbitrate in?
I agree with that, because these timelines are generally applied to all arbitrations, and it is impractical that every arbitration can be completed in a period of 12 months, and 18 months is not the time permitted by the statute. 18 months is only with the consent of parties. Right. So at the end of 12 months, if one party wants to delay the matter further, he is not going to give a consent to the extension, and the immediate recourse will be that you have to go back to court and seek, the arbitration comes to a standstill and you have to go back to court. And as Justice Shah said, with the piled up burden of the court already, this is going to add to the delays of arbitration. Secondly, I also feel that this will render arbitrators very vulnerable, right, because they are subject to a constant scrutiny of the court, as if they are proving themselves every moment to the court that I have not delayed it. And it will become a competition between each party to show who is delaying the arbitration. As a result of which, I feel this provision is going to lead to a whole lot of complication. Plus, also on the prospective part of it, when the Law Commission suggested a prospective application and that has not been incorporated in this ordinance, there is a great likelihood of it being also interpreted to mean that it will apply retrospectively, because some provisions have expressly stated even in the ordinance that they will not apply to pending arbitrations, whereas that is not there in 29A. So that is going to be another complications, as a result of which, till this issue is clarified, the entire pending arbitrations which have crossed 12 months will be at a standstill.
And that would apply, that concern about whether this is prospective or retrospective will apply to several provisions that we will discuss.
Of course
today.
It would.
But just to come back to the whole idea, Mr. Gupta, is for companies and groups and clients like yours to get, some sort of decision in a quick time frame. Is the government hopes going to meet that goal, or is this, as our guests have expressed so far, going to be counterproductive?
I only hope the timelines are being met. Now, I have a perspective, that too from business perspective.
Sure.
Now, the whole idea of putting in time limit is based on our Indian experience. 1940 Act did have the time limits done away with. 96 did not have it. It did not improve the position. One of the reasons for review of 96 Act is also delays,
right,
caused, and therefore total amount of money involved in this, dispute resolution is not happening on time, and loss of credibility in the system. As a result of which, many companies like us are now looking at arbitration outside India,
Correct.
where it is much faster. So despite the fact there is no time limit laid down in whether in Paris or the UK or Singapore or Hong Kong, invariably arbitrations matters are decided within a year or so,
Right.
even though the matter is complex. That is working, I think, because the system is attuned. The entire holistic system of arbitration, be the arbitrator institution or the parties, they are subjected to certain discipline which need to come in. And therefore, if you look at these experience outside India and in India, would you not think twice that I wish there is some period or time limit laid down for disposal of those cases?
Right.
Now, that may sound very unrealistic given our way of thinking, but we can debate on 12 months or 18 months, but from business point of view, we definitely would like a certainty within which the matter will get resolved, and that too of a commercial nature.
So you're effectively saying that despite the pitfalls or the flaws that have been pointed out by Justice Shah, been seconded by Mr. Saraf, you feel comforted by the fact that there is now a fixed timeline?
Yeah, whether it works or not, because many statutes have provided for time limits.
And they've not necessarily
worked. That did not work.
Right.
So, I mean, going by Indian experience, I don't think it's going to work.
But you still feel comforted
but
by
I
the
would
fact
like
that
to have certain guidelines, if I were to say this, where there is a definitiveness about resolution of a dispute.
Okay. Justice Shah, how would you respond to that concern? This is the concern coming from those, for whom arbitration is
yes,
a material issue. Yes.
Of course, that's a material issue. Delay is a material issue. The question is whether fixing timelines is a solution. Secondly, this whole idea of incentive to the arbitrators, if they decide the matter in a particular time, is dangerous. I mean, justice delayed is justice denied, but justice hurried is also justice buried. And the other problem is that arbitration culture is completely missing in this country. I mean, arbitrations are treated like a traditional litigation. I mean, look at where is the commitment either from the arbitrators or from the legal fraternity to decide the arbitration's timely manner. See, CPC, Evidence Act, all this is excluded by the arbitration law. But with so many retired judges doing arbitrations, I mean, all these technicalities are brought back in the arbitration. The whole attempt of the commission was to remove all these technicalities, the hurdles which become hurdle in timely decision in deciding the arbitration in a timely manner.
So barring this provision, can we examine the ordinance for the other provisions that also include strict timelines and see whether in themselves they are sufficient to provide for speedier arbitrations? For instance, Mr. Saraf, if I may bring up the amendments to section 9 and 17,
yes,
which have to do with interim measures. Of course, the purpose of those amendments is far broader, but there as well you can see that it says that the arbitration must commence within 90 days of the court passing an interim measure order. The section 24 amendment, which says as far as possible hold oral hearings on a day-to-day basis and do not grant any adjournments and impose costs on parties seeking adjournments without sufficient causes. If you were to take out this fixed time limit bit and look at the other provisions that include fixed timelines of some sort, would they in themselves be enough to create speedier arbitrations?
They would be enough, but they are certainly a step in the right direction. Very often earlier, a party used to take an interim order and then not even commence arbitration proceedings. For days together, they never used to commence arbitration proceedings. Though the Supreme Court had said that you must take immediate steps for commencing arbitration proceedings, there was no deterrent on the party who has already secured an order. So now there is a compulsory provision that you must go to arbitration and you cannot sit over an interim order.
Right.
Similarly, there are also timelines prescribed for the courts for disposing of proceedings. It's like a section 11 proceeding for appointment of an arbitrator must be disposed of, I think, in 60 days or something like that.
Correct.
Then there is a timeline. I mean, I understand that these may not be strictly adhered to, but there is certainly now a principle which is laid down in the ordinance which will weigh with the minds of the court that I have a timeline to meet. A challenge petition must be decided within 1 year. So these are timelines which will certainly help in bringing about a mindset of arbitration both for the courts as well as for the parties that they must expedite.
Okay.
But certainly this day-to-day hearing part of it, which is provided in the ordinance, I think is over-monitoring an arbitration. And to some extent I feel it's an interference with party autonomy, because how an arbitration should be conducted should be left for the convenience of the parties and the arbitrator, as long as it's done expeditiously.
Okay. You know what's curious about the amendments to Section 9 and 17, Justice Shah, was that the Law Commission had in fact set a limit of 60 days, saying that the arbitration must commence within 60 days of the court passing an interim order, and if it doesn't, then the interim measures would lapse thereafter. What has been included in the ordinance is 90 days instead of 60, and the provision for the interim measures to lapse have not been included from what I understand. So in some senses, where you all did make fairly solid recommendations to stick to stricter timelines, maybe not all of them have been adopted in entirety, whereas this fixed time limit thing has been imposed when you all didn't make the recommendation.
No, there are some provisions might not have been adopted, and I really, these are according to me, not very major issues. For example, we have recommended that now it is Section 11 should be decided within 60 days. But new Section 11, the court's role is very limited. The court has to just satisfy whether prima facie an arbitration agreement exists between the parties, and that need not take much time, and then it can be easily decided. And the whole idea of this 60 days or 90 days timeline to be brought in Section 9 or Section 17 is to start the arbitration immediately. So you have to, these efforts must be made in different ways. There is the idea that if you don't decide, then the arbitration will come to an end. That's not a correct solution according to me.
Okay. On this issue, I'm going to give one quick final word to the client, so to speak. Mr. Gupta, you've heard all the concerns. Do you feel confident at the end of this ordinance, when you read it, that yes, things will get done quicker, whether because of this one provision or several other provisions that have timelines?
I am only hoping, but I don't think it is going to work like that. Because as you use the right word, convenience, if it is convenient to one side of the party, you would like to use that convenience to defeat finality in the matters.
Okay.
And that's the problem.
If parties did want to finish arbitrations quickly, you would have never needed a law to tell you, hey, look, this is the timeline within which you have to finish.
And that's the context I'm talking about.
And that's the missing culture that Justice Shah talks about.
Exactly.
As
So
well.
therefore, if that missing culture, that's why the arbitration has not taken off in India.
Yeah.
The reason is I don't know whether it's going to work, and even if I get a arbitration award, how I'm going to enforce it, on what ground it is going to be challenged. So therefore, despite the fact we know this is the most effective way of bringing about commercial disputes to a rest, it doesn't work like that. Everybody is looking for a judicial order, because there is finality attached to it, there is some sanction attached to it, and that's the problem there. So the way the scheme has been framed, it is not a theoretical arbitration law where parties would decide amongst themselves, but where judicial intervention is brought in is a good feature in my view, because if the parties are going adrift, people can go to court and bring them online. So the whole intention should be resolution of dispute through this mechanism. As the system would mature, perhaps we'll have further refinement of this act, where judicial intervention would be further reduced.
Well, you've raised, Mr. Gupta, the most contentious issue of judicial interference, and that is exactly the next point that I want to discuss. But that's going to happen right after this commercial break. Stay tuned to The Firm. In 2003, in the Saw Pipes case, the Supreme Court allowed for a domestic arbitral award to be challenged on grounds of patent illegality, thereby expanding the scope of public policy as a ground for setting aside an arbitral award. Subsequent Supreme Court decisions extended that view to foreign arbitral awards as well, opening the door to increased judicial intervention in arbitration. The ordinance now seeks to limit judicial intervention by providing that a court can set aside an award as against public policy of India only if it is affected by fraud or corruption, or is in contravention with the fundamental policy of Indian law, or is in conflict with the most basic notions of morality or justice. It also clarifies that determining whether an award is in contravention to the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Only Indian arbitral awards can now be set aside on grounds of patent illegality, but not merely on grounds of erroneous application of law or by reappreciation of evidence. Finally, the amendments also provide that filing of an application to set aside an award does not render the award unenforceable unless the court grants an order of stay.
Just let me explain this aspect. I mean, as I said, that the problem is with the court expansively reading the powers to interfere with the award. In 1994, as far back as 1994, the Supreme Court said that the award will be set aside on the ground that it is opposed to public policy if either it is against the fundamental policy of Indian law or against national interest, and lastly, if it is against morality or morality or justice. We further restricted this to say that only when it is opposed to fundamental policy of Indian law or the very basic concepts of morality and justice. So it's like basic concept of morality of justice, say child labor, or say which is universally considered as immoral or unjust, and not mere what the judge feels, what is just and what is moral. So therefore we said very basic notions of morality and justice. Then we also clarified that the public policy intervention cannot be on the ground that the review on merit is not permissible under public policy. That is in view of the decision in Western Genco. A supplementary report was made by the Law Commission, and which was accepted by the government. So today the interference in an award in a commercial international commercial arbitration is extremely limited. As far as the domestic arbitration are concerned, it is the view of the Commission that the powers of the court should be slightly broader than when it deals with the international commercial arbitration. So therefore, we recommended that there should be a separate, that is 34(2)(a), that the award is vitiated by patent illegality. So these are the words used, and it is also clarified that mere wrong application of law is not a sufficient ground for setting aside the award. It's not permissible for the court to reappreciate the evidence and on that basis set aside the award. So even that 34(2)(a) is a very restrictive ground. But believe me, the way in which some of the awards are passed in this country, there has to be some power with the court to intervene and set aside a completely perverse or completely illegal award. So that is very necessary. So therefore we try to make a distinction between the court's power in dealing with the international commercial arbitration and the court's power in dealing purely domestic awards. And I feel that this has restricted the scope of the interference to a large extent.
Okay, I'm going to ask both my guests here in Mumbai if they agree with you, sir. Mr. Saraf, first up, when I was talking to a few arbitrators, lawyers, senior counsel in Mumbai, some of them raised issue with the wording of fundamental policy of Indian law or in conflict with the most basic notions of morality or justice. So they said, what's the difference between basic notions of morality and justice and most basic? Now, it may seem as if I'm splitting hairs here, but these are things that do end up getting litigated in court, right? So I want to get your view on what you think of the attempt to limit the scope of judicial interference. Is it a successful one based on what the Law Commission recommended and what the ordinance has adopted?
All this depends on with what a mindset the courts interpret these provisions. It is important that the courts interpret these provisions in the spirit in which they have been incorporated. Otherwise, take a word, patent illegality. Anything can be patently illegal. Now, while the the Law Commission and the ordinance says that erroneous application of law will not be a ground. Now, what is an erroneous application of law and what is a patent illegality is a very thin line. So, it will ultimately be, if the courts want to expand, even in the 1996 Act, error of law was not a ground available as a ground under the 1996 Act, but it's the court's judgments which interpreted public policy of India to bring about an error of law as a ground in the provision. So if the courts want to expand this, anything can get expanded. This word fundamental policy of Indian law can be expanded.
Or most basic notions, and not just basic notions.
Very often we've seen that the courts have heard arbitration challenges like a first appeal, decided whether to set it aside or not, and then gone reverse to fit it into one of the grounds. That's how it works. So it is ultimately how the courts will, as much as Justice Shah spoke about the arbitration culture, it will have to develop with all the participants in the arbitration, the parties, the arbitrators, the lawyers, and also the courts. So without that, these provisions are not going to curtail judicial intervention.
Mr. Gupta, your experience of having to get judges in India to not interfere, as opposed to, let's say, anywhere else in the world when you do a foreign seated arbitration, do you ever hear of the judiciary wanting to step in on any of these grounds, whether it's fundamental policy or most basic notions of morality and justice or patent illegality?
You know, first of all, judiciary intervenes at the instance of the party. They don't do it on their own. And the question is, they interfere only when they find there is some merit in it.
Okay, let me rephrase my question. What could be in an ordinance, if at all the ordinance or a law is the answer to this problem, what provision would have been better than this, or is this the best we could have had to narrow the scope of judicial interference?
You know, left to ourselves, we need to be very specific, list it down. But then it is challenges human limitation of thinking through and anticipating all possible reason on which it can be challenged. So that's the real challenge. That's why the word of general expression are normally used. But these expressions are not desirable expressions at all, for the purpose of bringing about finality within a defined period of time.
Justice Shah, you know, similar provisions or similar recommendations have been made for foreign arbitral awards as well, that is judicial intervention in foreign arbitral awards, if I understand that correctly. Your last word on this issue of judicial interference, are we going to see courts and judges interpret this ordinance and this provision in the right spirit and therefore reduce the interference?
I agree with Mr. Saraf that there is also need to change of mindset of the judges in dealing with the arbitrations.
Is that going to happen, sir?
I hope that it will happen. I hope that it will happen. Just see, in Renu Sagar, when the court defined the public policy, the subsequent judgment in Lal Mahal, a two-judge bench headed by Justice Lodha, as he then was, held that this would also apply to SOFIPE will also apply to international commercial arbitration. But surprisingly, the three-judge bench presided over by Justice Lodha ultimately acknowledged that this earlier decision was erroneous, and the international commercial arbitrations award should be tested on the basis of the law laid down by Renu Sagar, and it's a much restricted ground, and believe me, Renu Sagar has worked well. By and large, the interference in international commercial arbitration is much less than it is in the domestic award, and hopefully we have further restricted the grounds as defined in Renu Sagar. So hopefully, I mean, there will be some change in the approach of the court as well.
Well, the next talking point I want to bring up is yet another unique feature. India will become, if not the first, amongst the first few countries to impose a fixed fee schedule for arbitrators. We'll talk about that right on the other side of this quick break. You're watching The Farm. The appointment of an arbitrator is now the job of the higher courts. The ordinance also permits a court to designate the same power to a person or institution, and such designation is neither delegation of judicial duties nor open to appeal. It also limits the court to confine itself to the examination of the existence of the arbitration agreement only. Together, the amended sections 11 and 12 provide for pre-appointment disclosure by the arbitrator regarding qualifications, independence and impartiality, and time available to complete the arbitration in 12 months. India will be the first country to implement the IBA guidelines to determine conflict of interest and hence the independence of the arbitrator. Also, it is for the first time that India has introduced a fixed fee for arbitrators.
Now, the fixed fees is not something unique. Now, for example, ICC has a fixed fee schedule. There are many arbitration institutions which prescribe a fixed fee schedule depending upon the quantum of the claim. I mean, there is nothing extraordinary about it. And what the ordinance says, or what the amendment says, that the court may fix the fees and having regard to the fee schedule, and the fee schedule is reasonably good. I mean, that is improved upon the existing fee schedules of Delhi High Court and Madras and the Punjab High Courts. So according to me, it's a very reasonable fee, and it is to be revised every 3 years or 5 years. And secondly, as far as the conflict of interest is concerned, what we have incorporated is the IBA guidelines, International Bar Association's guidelines. They are called orange list and the red list. If it falls in the red list, then the simply arbitrator his appointment is void. The arbitrator cannot be appointed. Insofar as orange list is concerned, arbitrator is obliged to disclose whether there is any conflict of interest. And just another aspect, I mean, India is the only country where the officer of a party or a past employee or the serving employee is appointed as an arbitrator, right? This practice is prevalent in the public sector. So the commission is of the opinion that such practice should be completely discontinued. I mean, it's really, I mean, how a party cannot be an arbitrator in his own case. Similarly, a party's own employee or official cannot be an arbitrator in the process of adjudication. So I feel that this would really help in getting in enhancing the independence or impartiality or the test of impartiality and integrity of the arbitrator.
Okay, Mr. Saraf, are we going to end up with different high courts having different fee structures? Because effectively it's been left up to the High Court with a reference to the schedule of fees that's been laid down in the ordinance. So, you're going to have to answer this from both points of view. A lawyer involved in several arbitration cases as well as an arbitrator. So your fee is now going to be determined by this.
Honestly, in India, the fees and the issue about fees had reached a situation of a menace. So this was...
Were you getting paid too much or too little?
No, not me, but it was an issue which was there in large number of arbitrations where the fees were going out of hand and the arbitration was becoming too expensive.
But companies or clients have the choice not to go to those arbitrators. Why must we behave or pretend as if this was being forced down their throat?
That's exactly the point I was coming to, that institutions have a fee structure. While in India, we have now introduced what I feel is a statutory institutionalization. In India, because there were no institutional arbitrations, the statutes have kind of created an arbitral institution now, laying down all guidelines.
Timelines, fees, processes.
Yes, Section 12 about the impartiality, and everything is laid down in a statute. Now, instead of that, I feel the government should have encouraged a vibrant institution coming up in India which would have monitored all this.
We do have some institutions that are doing good work.
We could have encouraged them. We could have had something more. We have institutions in Singapore, London. We could have encouraged that. But I really do not feel that this kind of a statutory institutionalization is a very healthy thing, because it's not there in any other statute. This is like almost having a court-governed tribunal. It's like a court-governed tribunal in everything from fees to every aspect, and also the impartiality issues is certainly going to reduce the pool of arbitrators in India to a great extent, and it is likely to be abused, because suppose a former judge had given an opinion to one party 2 years back on a completely unrelated issue, and he discloses that as a ground of impartiality, which I don't think is a ground at all. The other side who wants to have him removed might just raise an objection and say, I have objection to you continuing as an arbitrator, and there goes an arbitrator from that. So there is a great likelihood of abuse.
These guidelines are, they work very well. I mean, these guidelines are followed all over the world. I mean, no one finds any problem with these guidelines. I mean, the impartiality and integrity and independence of the arbitrators are very, very important matters. I can just give you one example. It has come to notice that certain corporate bodies are appointing only same arbitrators in matters after matters. And this is it not a case therefore the arbitrator, what we have provided, if the arbitrator has been appointed, has acted as arbitrator for this a particular party more than 3 times or 4 times, I mean, he should disclose this to the other party. Still may accept him as arbitrator. But we should apply international standards for determining the.
No, I do not say no. All I mean is, why in a statute like this, sir? These are best left to the institutions which govern that.
But we don't seem to have.
No, there is no institutional arbitration in India.
But that needs to be developed.
95% of the arbitration is
ad hoc.
And the other problem is, you have some institutions. I don't want to name them. But tell me one institution in India which can be said to be on par with, say, LCI, London, or ICC, or any other international arbitration institution. So actually, in the report we have recommended to the government to in fact there are some provisions which were recommended by the Commission to encourage institutional arbitrations. Unfortunately, they are not incorporated in the
ordinance. That's precisely what I meant, sir, that we should, rather than incorporating such provisions in a statute, the government should have taken steps to encourage an institution to be set up which could have monitored and governed all this. That was the need, not a statute in this regard.
So, it's a baby step. You have to look at the perspective. Number one is where will the institution be created? What sanction authority would they have? Would they enjoy the respect of the community at large?
Are you happy with fixed fees?
Actually, I'm happy on all fronts on 3. Number one, the fees part of it, disclosure of conflict of interest, because then I don't have to rake up my mind, is the arbitrator good, not bad, impartial, going to be impartial or not, So you like because the provisions are for very extensive disclosures, to be honest. You have to, there is a pre-appointment disclosure, then you have to fill up a full form, and make all these disclosures. Disclosures are never bad. I'm not opposed to it, but this will give you more comfort. Absolutely. And secondly, from arbitrator point of view also, something may strike his mind and he's debating whether I disclose or not. It may not strictly be a disclosable thing. But if you lay down the factors to be considered, it's easier for him to say, oh, I see, I need to declare it. So I personally feel it's good for the arbitrator, good for the parties.
And you're also happy with the reduced judicial intervention, at least on paper?
Yeah.
At least on paper?
No, absolutely, I am actually.
Though I know Mr. Saraf has a different view on that slightly. When we discuss the core issue of setting aside, an arbitral award or not, there it does seem on paper that judicial intervention has reduced. But otherwise, your argument is that at various steps, these amendments take the process back to court.
Yes, it
and
does.
Keep involving the court in the process, so to speak. So the court is the monitor.
Including 29A, where at every stage of delay, the court is a monitor.
Right. And that's a little counterproductive.
Yes, it is.
It's counterproductive and it could be productive depending, for instance.
But you're still seeking comfort in the court, then why go for arbitration at all, sir? Then deploy litigation as your best tool, right?
No, ideally speaking, I would go for arbitration as I do for international arbitration in LCA and others. Why? It works.
Okay.
So therefore, you come to this conclusion, some kind of supervision at this point in time as we evolve is important.
Alright, so we've discussed the issue of timelines, we've discussed the issue of judicial interference, and we've also discussed the appointment of arbitrators, the grounds for challenge of arbitrators, and therein the fixed fee schedules. Well, when we come back from this quick commercial break, I'm going to ask my guests for their final thoughts on whether this arbitration ordinance is really going to make arbitration more effective in India. The other important amendments introduced by the ordinance are measures that will help expedite arbitrations. For instance, as I mentioned earlier, the ordinance provides that the filing of an application to set aside an arbitral award does not render the award unenforceable unless the court grants an order of stay. A new section on costs empowers the court or arbitrators to order the unsuccessful party to pay costs. In determining the costs, arbitrators may also consider whether any reasonable offer of settlement was made and rejected.
Just few aspects I would mention. One
Yes,
is
please do.
there won't be any automatic stay on filing a petition under 34.
Right.
So party will have to apply for stay. That's a very important provision. So this otherwise, every award is being challenged in the court of law, and the moment it is challenged, it becomes non-executable. So this has been now this has been changed now. So if the party seeks to get stay of the award, it will have to apply, and the court will consider the application in accordance with the CPC principles, broad principles under the CPC. Second important aspect is that now the award of actual cost is made almost mandatory. I mean, there are many times, I mean, the defenses before the tribunal or the proceedings which are taken to the court are completely frivolous. And ultimately, when such proceedings are dismissed, the other side must get actual cost. This would discourage the parties from filing frivolous petitions, I mean, in the court of law.
Okay. So then the final question, gentlemen, to both of you here in Mumbai, since Justice Shah has had the last word on that, and that is that I'm guessing the reason for why this has been brought about through an ordinance is because the government's very keen to be able to fix this broken system of arbitration and hence project an improved ease of doing business in India, because it was amongst the top complaints that foreign investors had, along with domestic investors in large groups. Is this going to be a dramatic improvement to the process that we have today, Mr. Saraf?
Surely this is going to bring about a big change. It has shaken up a lot of people, the litigants, the arbitrators. It now cannot have a system where an arbitrator has around 40 arbitrations and he does it at his own convenience. So it is now going to be a big step in the improvement of arbitrations in India. This is a welcome step. It is a step in the right direction. I only hope that the implementation of it is done in the same spirit, with the same purpose. And ultimately, if we continue with that spirit, we'll surely see India soon as an arbitration center.
Mr. Gupta?
I completely echo views expressed by Birendra. And another point which will bring about very interesting, and I welcome that, is you are asking the arbitrator before he enters into arbitration.
Can you finish this entirely?
Can you finish?
Yes.
I mean, that brings about a degree of responsibility that you really want to bring about.
Yeah.
I think these are very good features to my mind. The only thing is, of course, people are cynical to start with because they have tried many systems. It did not work. But it has many good features.
Justice Shah, I know that you raised the issue of whether this applies prospectively or retrospectively as a question that has yet to be answered, and we'll only find out in time why the government chose not to include the section that the Law Commission had recommended. But I'm going to give the final word to you on this. When we first started, and we started by speaking of fixed timelines, you said that issue or that provision really negates all the other benefits of these amendments. What would you say is your last word on this debate? Have we made a leap, a big jump forward in improving arbitration?
See, yes, of course. The big jump is that after 16 long years, the government has finally accepted the Law Commission's report, because the process of amendment started in 1999. So we are in 2015. So this government has taken that initiative and introduced an ordinance on the basis of the report. That's a very welcome step. My only worry is about these timelines and the absence of the lack of clarity on the retrospectivity or prospectivity of the particular provisions of the law. But I hope that with the new this new regime, I mean, there is some hope of improving the arbitration culture in India. It has really shaken up the legal community, in the sense that when I meet the other judges, and it's all a matter of discussion that about the timelines and the other provisions of the. So there will be some change in it will bring some change in the mindset. I mean, some that is needed to have a successful arbitration system in India.
All right, Justice Shah, I must thank you very much for joining us on this special show and sharing with us all the insights that enriched the Law Commission's recommendations to the government. And gentlemen, to both of you, thank you very much as well for your time and for your thoughts on this. With that, we wrap it up here on The Firm. Thanks very much for watching. We'll see you next week.